Hey Gail, hey Sandra. Um, hey guys. So I'm gonna try to make this a quick live. I know I always say that, but I'm actually waiting for. I ended up just getting a new microphone because I listened to the last live and it was bugging me so much, and that's why I actually put off yesterday's live, which I apologize. I should have done a community post because we're supposed to start the Adnan series. Adnan Saeed, we were going to talk about that, and I put it off because I was waiting for my microphone to come in because it's just bothering me that I'm not going to say anything about what it's doing because I don't want to put it in your guys' ear. And then, like, I would never have noticed it. I don't think if somebody didn't say, and then somebody said something, I noticed it. So I'm not even going to say what it is if those of you that didn't hear the last one. But it should be coming later today. But I didn't want to wait for this because I wanted to just talk about all the new documents that are coming out with Delphi. It's pretty interesting, man. Oh my lord. So how many of you guys are aware of the documents that came out like 2 days ago? Or was it like 24 hours ago with I think it was the 25th is when they were written about with how Judge Gall just totally freaking ambushed the lawyers. Let me know if anybody didn't see it because I don't know if I'm going to I probably will read through those, but I don't know if I'm going to read through those first because I want to go through the stuff that's new that just came out. But has anybody not seen that by any chance? Have not heard that? What happened with hold on. Here, maybe we could kind of like just go through some of the. I don't know if I'm not. Looks like. Well, maybe I will go through this real quick. I'll try to be quick here. Because maybe there are some people that didn't get to actually see what happened, and then we'll go through the new stuff because there's some new documents that came out too that I want to go through. So, yeah, it's crazy. So there's two different documents. They kind of go over. I mean, the ones that I want to first go through that talks about what happened. So there's one that talks about the verified notice of a continuing representation, and then Razi files one to disqualify. He's trying to disqualify Gall. So I'm going to start with this one because it does point out, all the important things. So let's go through this real quick. Dude, Judge Gall is something else, man. If you could, I mean, thinking about like how we're talking about Carroll County and we're talking about, well, actually, where is she from? Hold on a second. Allen County, I think. It's Allen County. But we're just talking about law enforcement, how it's just corrupt and all the corruptness that's been going on with this case. And then we hear this crap. When I heard about this, I was a little behind because I'm editing that Patrick Westfall. I was editing that yesterday. I was that video, which I was going to combine it today, but I think I'm going to do it separate. I finished it, just pointing out some of the important things of the two Patrick Westfall's interviews. I'm going to break it up into some shorts and do one long one. But so I was working on that, and I wasn't even aware of this until this morning, or was it late last night? It's like, oh my God, I was so, like, when you're busy editing one thing, you miss like the new update. So it kind of sucks. All right, let me read this real quick. How do I sound? Does it sound okay? So I got a new microphone, so hopefully it'll be better. I'm just not happy with the way it sounds, but okay. So it comes now. This is the first thing. So this is from 2 days ago, and then, like I said, we'll lead up to the new stuff. Okay, because he was appointed two new lawyers, which we'll talk about, and then we'll talk about Razi not wanting to leave, which I don't blame him. Because remember, Baldwin, she comes out and she says Baldwin put in his withdrawal, but Razi didn't put it in. But she's like, he's expected to do that. Do you remember? Maybe we should watch that real quick to just like remember what she said. So let's start off by doing that real quick. Let's listen to what she says real quick, and then we'll read this. Okay, just to remind ourselves. Hold on. It's really short. It's only a couple minutes. Remember, she just comes out real quick. Then yeah, let's just watch it real quick, and then we'll couple minutes, and then we'll read it because it'll like make a little bit more sense. Okay, here's court TV. All right, so I hope my new mic is good though, guys. I hope it sounds good. All right. Ooh, I thought I had this. Okay, so Let's just watch this real quick, 3 minutes, and then we'll read the all the documents. Just to remind us what she said.
We on? All right, we are on the record in State of Indiana versus Richard Allen, 08C012210MR1. Thank you for your patience, ladies and gentlemen. Thank you, Mr. McClellan, Mr. Luttrell, for your patience. We've had an unexpected turn of events, ladies and gentlemen. Earlier this afternoon, the defense attorneys have withdrawn their representation of Mr. Allen. Mr. Baldwin made an oral motion to withdraw. I granted that oral motion to withdraw, and Mr. Rosie will be submitting a written motion to withdraw, I'm assuming within the next couple of days. They have confirmed with the court that Mr. Allen's financial situation remains static, meaning he is continuing to be entitled to appointed counsel. I will reach out to public defenders to make that appointment. As Mr. Allen is now without counsel, I've ordered him transported back to the Department of Correction.
Sorry, I'm mad at
Mr. McClellan, I know that we have already scheduled a hearing in the Carroll Circuit Court October 31st at 9 a.m. I'd like to maintain that hearing if we can, please. I think at that point we can have counsel appointed. I'd like to set a new trial date. Obviously, I don't believe counsel will be prepared within the next couple of months to try a case of this magnitude in January. So we'll set dates for the trial. I think we need to set a date as well for the suppression hearing that was filed now by former counsel. I have asked the attorneys to provide all of the discovery previously provided back to the state of Indiana. I know I entered a protective order on the discovery, and honestly, I don't remember when that was. I think it was in April of this year, perhaps, maybe sooner. But the attorneys have been ordered to provide all of that discovery back to the state. And if you would maintain that until such time as it can be turned over to successor counsel, I would appreciate that, Mr. McClellan. I've also asked the defense attorneys to cooperate with successor counsel. They're not required to do that, but I think that they will in the best interests of Mr. Allen. They're not required to provide any of their work product, but they will be required and have indicated that they will cooperate with successor counsel. So obviously, without counsel, Mr. Allen's hearing cannot proceed. I apologize that I know many of you have been waiting for several hours. I know, Mr. McClellan, you and your staff, and you had some witnesses here that came earlier to have the hearing, but clearly this is outside of our control. So is there anything, Mr. McClellan, that you'd like to state for the record?
No, Your Honor, I think we can address the other issues at the October 31st court date.
All right. With that being said, then, we are in recess. Thank you. I'll see you in October.
Okay, so I just thought that was important to watch that because you'll see. Maybe I should have played that after we read the freaking document. So those of you that aren't familiar with them, what a freaking jerk. Okay, so unexpectedly, we're all watching that thinking, God, why did they do that? They must, thinking all these things, like kind of upset that they withdrew. And then we learn what really happened, which is it. When I look at her face now, I get so mad. I'm like, what? Like, liar. All right, hold on. Saying, what? Are you Willy Wonka now? So you didn't like being a fish because you can't have candy as a fish. I get it. Trust me, I'm a candy addict. So, all right, hold on. Let's go through. You cracked me up. Okay, so now Rosie is trying to disqualify the judge, which I hope he can, because now I'm afraid he isn't going to get a fair trial. Because look how, I feel like that just shows her bias to what they were like that defense of going that route. I feel like it just shows that she's going to be biased to that defense and that story with the Odinism, or you know what I'm saying, or painting a picture of that it could be somebody else. I feel like she's going to be impartial to that now. It's just not fair. Oh, this is what got me frustrated. Okay, let's read this real quick. Do I sound somewhat okay, you guys? I know the mic isn't the best, which I don't know what happened to it. I tried to unplug everything again, and it's just making me really mad, but hopefully it's not that bad. Okay, so let's read this, and like I said, it will just lead up to all the new stuff. All right, so procedure, okay, here we go. Procedure respectfully and moves for recusal of and change of judge from Judge Francis Gall. So he motioned to disqualify. He's trying to get her disqualified. So Rule 2.11 of the Indiana Code, judicial conduct requires a judge to disqualify himself or herself when judge's impartiality might reasonably be questioned. Such is the case in this cause of action for the reasons described below. The comments to Rule 211 provide additional guidance. Under this rule, a judge is disqualified whenever the judge's impartiality might be reasonably questioned, regardless of whether any of the specific provisions of paragraphs through 6 apply. In many jurisdictions, the term recusal is used interchangeably with the term disqualification. A judge's obligation not to hear or decide matters in which disqualification is required applies regardless of whether a motion to disqualify is filed. A judge should disclose on the record information that the judge believes the parties or their lawyers might reasonably consider relevant to a possible motion for disqualification, even if the judge believes there is no basis for disqualification. I think I said the opposite when I said impartial. No, I think I used that when I was talking about it earlier. I reversed it. So if you guys are like, wait, you said that wrong, but okay, so Judge Gall has removed and concealed or allowed to be removed by the clerk of Carroll County defense pleadings from the chronological case summary in violation of the Indiana Supreme Court. Okay, those pleadings include Frank's motion filed 9/18, Frank's memorandum filed 9/18, 3 affidavits from Warden Gallipew, or however you say his name, Sergeant Jones and Sergeant Robinson's filed 10/10, an affidavit of the leaker Mitch Westerman. Judge Gall has not removed or hidden any state filings. Indiana Access to Court Records Rule 2A provides in pertinent part all persons have access to court records as provided in this rule, and that the certain persons have greater access to court records. The commentary to ACR rule is that all persons, including members of the general public, the media, and commercial and non-commercial entities are entitled to the same basic level of access to court records. A court record is accessible to the public except as provided in Rule 5. Provides that certain entire cases shall be excluded from public access without notice of exclusion, but this entire case has not been declared confidential by statute or rule, and meets none of the other criteria laid out in ACR rule. Okay, I want to go down to what she did. Maybe I should have read the other one first, but as far as like the specifics. But it says, because those acts have only shielded documents from the defendant, these actions clearly demonstrate a lack of impartiality and fairness in violation of Judicial Rule 1.1. So on October 12, 2023, Judge Gall instructed appointed counsel to cease work on Mr. Allen's case, which interfered with the attorney-client relationship and prejudiced the accused by denying him the timely, effective representation guaranteed him by the state and federal constitutions. Because think about it, they have a freaking trial coming up in January. I mean, that's not that far away, really. And she wants them to stop working for a whole week. Cease working, okay? Well, we know now because she's planning on not giving them a choice. Either they're going to be disqualified or they have to withdraw. You know what I'm saying? So we get, now that we could look back on everything, we see why she did that, which is wrong. I'm saying it's so wrong what she did. So on October 19th, Judge Gall conducted a critical stage proceedings in chambers outside the presence of the accused, even though she had ordered him transported and he was available. She then did the same after placing his attorneys in an ethical dilemma and again creating a public record outside of the presence of the accused. This ignored clear precedent. On October 19th, Judge Gall ambushed appointed counsel with a planned Hobson's choice designed to coerce withdrawals. The choice presented was to suffer a public shaming and be removed from the case or to voluntarily withdraw, despite defense counsel requesting clarification as to the topics or motions to be addressed at the October 19th hearing. She gave defense counsel no notice of her plan to force withdrawals or remove them, thus denying counsel the opportunity to adequately refute her accusations. The same day, Judge Gall had prepared a statement that she threatened to read to the public, alleging defense counsel was grossly negligent in the representation of the defendant Allen. Judge Gall's complaint was more about not having control over counsel rather than any legitimate concerns that counsel had engaged in conduct that compromised Richard Allen's defense. A general summary of Judge Gall's complaints are as follows. A press release, generic in substance, was issued by the defense in November 2022 before the court's gag order and only after repeated press conferences by the prosecution. Allen's response. The intent was only to level the playing field. This was well within the obligations of defense counsel by established guidelines. She never expressed any concerns over the multiple press conferences by the prosecution. What's up, Peyton? Hey, Sharon. 2 motions filed by the defense, one of which addressed the health and safety of the defendant Allen, and the second of which addressed the immediate transfer of the accused due to the not so coincidental and undisputed facts that individuals engaging in Norse paganistic practices may have not only murdered 2 girls, but they were also escorting defendant Allen around the prison at the same time his health was in rapid decline. Allen's response. The court had previously ordered the accused transferred to a state prison at the request of Carroll County Sheriff. His mental and physical health began in immediate decline. Prison guards in his area had Odinist emblems on their uniforms, which endangered their client after the Odinist connection was exposed. The defense had video of the patches, and the guards admitted they wore them. The defense had previously noted a connection between the murders and Odinism. The patches have since then been removed. Mr. Rozzi cited instances of abuse. The filings were within obligation established guidelines and posed for effective representation. Mr. Baldwin had drafted an email to co-counsel but sent it to the wrong person due to self-populating in electronic mail. Allen's response. This was an accident that happens routinely to most people. The intended recipient, attorney Bradley Rozzi, and the unintended recipient share the same first 3 letters of their first names. The email attachment contained no substantive information, just bare bones outline of a tiny portion of the discovery received by the defense in this case. Okay, so the first 3 letters, so it began with a BRA. Okay. The court alleged that Mr. Baldwin put improper statements in his Franks memorandum, not false or misleading statements, just improper in her opinion. Allen's response. The court had disdain for the defense for not filing it under a seal, even though there was no order to do so. That memorandum was demanded by the prosecution before there could be a Franks hearing. It is an impressive piece of legal writing and has been lauded by expert defense counsel across the nation. It again was required by applicable guidelines. So, yeah, they had to write the memorandum for the Franks hearing. So it had to be done. It had to, you see what, what are they supposed to do? The prosecution demanded it in order for there to even be a Franks hearing. There had to be some probable cause for it. You know what I'm saying? There had to be like a reason. So they write this memorandum to show that, and now they're getting reprimanded for it. Okay. That Mr. Rozzi had filed a tort claim notice to preserve the rights of his client. The court opined that this action amounted to gross negligence. I don't know what they're referring. Let's see. Allen's response. The filing of the notice was intended to preserve the rights of a man who was shuttled off to one of the most secure detention units in the state, locked up and isolated with only a tablet, which was often dysfunctional to communicate with the outside world. Allen had no ability to speak with his wife in private, as his phone calls were all being recorded. Allen's own attorneys were required to make advance reservations to visit him at the prison. It is entirely impractical that Allen would have had means to prepare his own tort claim notice and or secure private counsel to do so. Now, the whole thing of recorded phone calls, when you're even in jail, everything's recorded. So I don't think he should get privileged phone calls with his wife, but he should get privileged meetings with the lawyers, though, because I feel like it doesn't matter if you've been convicted. If you're in jail or if you're detained, and you use a phone, if it's not lawyer, your lawyer's meetings, like it's going to be recorded. So that he should, yeah, but no, for the most part, I agree with the lawyers. Definitely. Hey, Morningstar. Okay, so Mr. Baldwin hired a lawyer to represent him in this matter. Wait, he's getting, hold on, he's getting like crap about him hiring a lawyer to represent him? Anyway, Allen's response, was not true. Mr. Baldwin was betrayed by a friend, and there is a subsequent related unaliving. As a friend and colleague, David R. Hennessy suggested he needed a lawyer to speak on his behalf, and he volunteered. No fee was arranged between the two. The court also alleged undersigned had put volatile facts in the memorandum regarding possible sanctions or disqualification. The true facts in a criminal case are often volatile. There was no untruth. And then the dissemination leak of crime scene photos in which neither Attorney Rossi nor Attorney Baldwin had knowledge of nor participated in. Allen's response, see affidavit of Mitch Westerman previously filed. So Guideline 1 of Indiana Public Defender's Council states the paramount obligation of a criminal defense counsel is to provide zealous and quality representation to their clients at all stages of the criminal process. Similar obligations are recognized by the American Bar Association, the National Legal Aid and Defender Association, the National Advisory Commission, blah, blah. It says everything cited by Judge Gall as concerning was either not attributable to Attorney Rossi or excellent and ethical lawyering in the best interest of the client's defense and mental and physical well-being. Throughout the pendency of this proceeding, the defense has exposed untruths by law enforcement, withholding of exculpatory evidence by the prosecution, and discovery violations about which Judge Gall showed no concern and did nothing. The court has routinely expressed umbrage at defense counsel's representations through investigations and filings while silently abiding the prosecution's discovery delays and false statements by them or their agents. On October 19th, Judge coerced an oral request to withdraw from Attorney Rossi that did not comply with Rule 3.8 Indiana Rules of Trial Procedure, and further coerced an oral request from Attorney Baldwin to withdraw as co-counsel in this cause. Judge Gall has exhibited a lack of concern about taking no action to protect the physical and mental health of the accused. Throughout these proceedings, Judge Gall has exhibited a bias and prejudice against the accused and his attorneys and in favor of the prosecution. Counsel for the defendant are appointed proper counsel upon appointment. Judicial control and oversight of the appointed counsel is inappropriate. The court cannot and should not dictate the process of representation of improvidently curtail the representation of counsel. It has done so without notice to the defendant or his counsel, affording them an opportunity to be heard. It has also done so of its own accord without any precipitating motion or request. No due process has been afforded. He says, as previously stated, Judge Gall strong-armed attorneys Rossi and Baldwin with a prepared statement that she intended to read into the record had either attorney resisted her efforts to remove them from defense. Within minutes, Judge Gall took the bench, started the record, and informed those present and viewing public that there existed an unexpected turn of events, which we just watched. She does say that. She acts like, oh my God, they withdrew. What a freaking liar. Anyway, with the defense team withdrawing from the case, Judge Gall further stated that these circumstances were clearly outside of our control. Oh, what a liar. The only clarity offered up by these statements is that they were entirely inconsistent with her actions in chambers just minutes earlier that forced the attorneys to consider withdrawal in this matter. These words run afoul of Rule 2.1 as they demonstrate the tribunal's lack of integrity and partiality toward the public and assert defendant Allen's rights to competent legal representation. Yeah, so hold on. This might go into a little bit more. I'm not going to read it all, but some of the stuff maybe that wasn't included. Yeah, so on 12th, they ordered them to cease work in his case. until the 19th hearing, which we knew what her plans were. She was either going to disqualify them and basically embarrass them in front of everybody, or they were able to withdraw themselves. I knew there was something up. I just kept thinking maybe they were afraid of them somehow going to get in trouble, that they would just, because you know how people will be like, oh, you could quit or you could resign, or, you know, like one of those things where you have two options where people don't really want to resign or quit or withdraw, but they do it because they don't want the other option. You know what I'm saying? So part of me was thinking that maybe they were thinking that they were going to, you know, possibly be able to get in more trouble, so they just wanted to withdraw. I never would have guessed that the freaking judge did that. No, that wasn't even on my mind. But I was thinking that there was some kind of thing, something they were afraid of, you know? I did think that, but my head did not go to what really happened at all. So yeah, on October, so this goes a little bit more specific. We'll just read real quick. So parts of it. October 19th, attorneys Rozzi and Baldwin appeared at the Allen Courthouse in advance of the 2 p.m. hearing. This was prompted by Attorney Rozzi requesting that the parties communicate in advance of the scheduled hearing. Attorney Rozzi and Baldwin appeared in chambers on the 19th at approximately 12:30, at which time the prosecution was present. Attorney Rozzi is of the understanding that the court reporter secured an audio recording of the inner chamber conference, which took place in two parts. The court first conducted business as it related to several pending motions by communicating with the parties and issuing rulings on said motions. The court then read a prepared statement to the attorneys Rozzi and Baldwin, identifying various issues throughout the case through which Attorney Rozzi and Baldwin exercised gross negligence in carrying out their responsibilities as counsel for Defendant Allen. The court then suggested that Attorney Rozzi and Baldwin engage in a discussion outside of chambers regarding the allegations. Attorney Rozzi and Baldwin asked for clarification, at which time the court communicated to Attorney Rozzi and Baldwin that there are two distinct options. Either voluntarily withdraw their appearances and exit the courthouse in advance of the hearing, or two, participate in the 2 p.m. hearing in the courtroom where a media camera was installed, the national media was present, and the law enforcement community was seated in the jury box directly behind defense counsel table, at which time the court would read the prepared statement into the record and then disqualify both Attorney Rozzi and Attorney Baldwin in the presence of Defendant Allen, his family, and the general public. What a freaking, After waiting approximately 1/2 an hour for Defendant Allen to arrive at the courthouse, Attorney Rozzi and Baldwin communicated with Defendant Allen regarding the stark choice the court had offered in chambers. Defendant Allen reaffirmed his desire to move forward under the representation of Rozzi and Baldwin. As of October 24th, Defendant Allen objects to the court's attempts to strip him of his current counsel. Attorney Rozzi and Baldwin, where are you? Oh, Attorney Rozzi and Baldwin. Okay. They're saying that's his current counsel. After speaking with Mr. Allen, Attorney Rozzi and Baldwin then returned to chambers, at which time Attorney Rozzi articulated to the court that the court had engaged in an ambush of defense counsel entirely void of due process, and that Attorney Rozzi would withdraw his appearance, but that said withdrawal was not a voluntary withdrawal, because the court had made clear that if Attorney Rozzi did not agree to withdraw, the court would publicly shame him in front of the world and his client before forcing him off the case by disqualifying him. All the events in chambers occurred without any formal allegations of contemptuous behavior by Attorney Rozzi or Baldwin, without any pending pleadings requesting disqualification of defense counsel, and without any pending disciplinary complaints with the Indiana Supreme Court's Disciplinary Commission. In total, Attorney Rozzi and Baldwin have practiced law in the state of Indiana for more than 50 years without a single substantiated finding of disciplinary action against either. At no time while in chambers did the court ever articulate to either Attorney Rozzi or Attorney Baldwin that their conduct compromised Defendant Allen's defense in any way. In fact, Defendant Allen himself doesn't believe this to be the case. There are no bona fide facts or circumstances where an Attorney Rozzi engaged in gross negligence, nor was there any showing that any conduct by Attorney Rozzi resulted in negative consequences to another party. Defendant i.e. defendant Allen. In sum, attorneys Rozzi and Baldwin did nothing to compromise Richard Allen's defense. Attorney Rozzi's oral acquiescence to withdraw his appearance as defendant Allen's attorney was forced, coerced, and driven only by circumstances created by the tribunal, which delivered two terrible options: quit or be shamed in public before being disqualified from representing Mr. Allen. The court premeditated ambush of the defense placed attorneys Rozzi, Baldwin, and the client Richard Allen in the most compromising position. The trial court's stated intention to read a prepared statement criticizing defense counsel created an impossible ethical bind. If counsel did not agree to withdraw in chambers, the trial court would publicly disparage their representation of the accused, framing their advocacy on his behalf as gross negligence, casting both counsel and the merits of their client's defense in a negative light. This public statement and circumstance created by the trial court risked tainting the jury pool, harming their client's defense, undermining their professional relationship with the client, and possibly creating an actual conflict for their continued representation. The jury trial in this matter is set to commence January 8th, 2024, a full 1 year and 3 months after the arrest of defendant Allen. The appointment of successor attorneys will prejudice defendant Allen by and through further delays in his case and trial. If, however, Attorney Rozzi moves forward with his representation of defendant Allen, there will be no need for two newly appointed attorneys to dedicate hundreds and thousands of hours toward a mere review of the discovery, which continues to pour in as recent as late September. There will be no need to marshal all the discovery and return it to the prosecution. There will be no need to bring up to speed new staff members, investigators, and possibly a new set of experts to address the many complicated issues that have already been addressed by the defense. A new defense team would likely result in shifting of the strategy and approach of Allen's current defense team, which in turn would further delay and compromise Richard Allen's defense. Finally, any successor lawyer would have the convenience of working with Attorney Rozzi to become familiar with his subject matter in a much more efficient and fiscally responsible way. All these truths weigh in favor of Richard Allen's choice to maintain Attorney Rozzi as his counsel of record. And it says that there's no rule in Indiana rules of professional conduct which warrant the withdrawal of Attorney Rozzi's representation of defendant Allen. Attorney Rozzi notices up this court of his intention to move forward with the representation of defendant Allen until a final disposition of this matter. Okay, so those are the first ones that came out. So let's go over some of the newer ones. Oh, hey, Gloria and Della, what's up? Hey, AJ, Petty, what up? All right, so now let's go over some of the new stuff, and we're going to go over the new lawyers because there's a new lawyer that has some possible issues. The specifics aren't known yet, but supposedly they're kind of maybe buddies with Gall. Of course, she picked him, right? All right, so and then there's a media denial that she denies media. So there's a few different new stuff. Okay, so let's go with this one. I'm going to go kind of in order. So on October 26th, this was the documents. And then the next one's going to be today, the 27th. Okay, so this is from October 26th, yesterday. Rozzi files for a motion for continuance. Okay, so he still wants to represent Allen. Well, it's obvious from the last one. So comes now defendant Richard Allen by counsel Bradley. Rozzi respectfully requests that this court continue the October 31st hearing set in this cause in support of said motion. Defendant Allen states follows. Counsel for defendant Allen is unable to locate any specific order wherein the court scheduled the initial October 31st hearing date, nor is there any order which articulates exactly what matters were to be addressed and how much time was to be set aside. However, counsel does acknowledge that there have been discussions between the court and lawyers regarding the October 31st hearing date and the possibility of the court conducting a hearing on the pending suppression motions filed by defendant Allen. So on September 18th, defendant Allen filed his motion for Frank's hearing. The court has yet to issue a ruling on said motion. October 2nd, defendant Allen filed his supplemental motion for Frank's hearing. The court has yet to issue a ruling on said supplemental motion. October 3rd, defendant Allen filed an additional Frank's notice. The court has yet to issue a ruling on the issues raised in that said notice. On October 14th, this court ordered defendant Allen's defense team to cease all work on defendant Allen's behalf and therein prohibited counsel from engaging in preparation for the October 31st. I thought it was October 12th, they said, though, but this is saying October 14th. Suppression hearing or any matters associated with this case. October 19th, the court engaged in actions which resulted in the court ordering the withdrawal of Attorney Baldwin from the case. So he's just saying Attorney Baldwin. Okay. Attorney Rozzi remains the only active attorney of record in this case. So this is yesterday. This is dated October 26th. And I'm breaking that up because I'm going to read you a document that's dated today. So right now he's saying he's the only active attorney, and then we'll see what happens today. On or about October 25th, Attorney Rozzi filed a motion to disqualify Attorney Rozzi, believes that a full and final disposition on the motion to disqualify should take precedent over the issuance of any rulings on the Franks motions. The disposition of the pending suppression matters and any other matters of substance which are currently before the court. Further, defendant Allen believes that any suppression hearing in this cause will require more than 1 day of the court's time and will require the appearance of witness, which most certainly cannot be secured between now and October 31st. It is for these reasons that defendant Allen requests that the hearing on October 31st be continued to a date and time following a full and final disposition. So we know, like in that last hearing where she's announced their withdrawal, she talks to Prosecutor McClellan, saying she still wants to have that hearing on the 31st. Well, Rozzi's saying, no, I think we should push it back because there's no way we'll be able to get stuff in time ready for what we need to discuss. Okay. So we have that. And then, this one, let's see. So this is the stuff that needs to be taken care of before the hearing on the 31st. So it says, court notes the following pleadings which may be resolved without further argument or hearing. Defendant's motion for broadcasting order is overbroad. The court will consider broadcast requests by the media, which she does make a decision on that, which we'll go over, which is bullcrap. But anyway, on hearing by hearing basis. So hopefully the way her attitude is now, if she doesn't get disqualified, I feel like she's going to always vote that way, but we'll see. Anyway, but at least for the 31st hearing she did. So therefore the motion for broadcasting order is denied. Defendant's motion to quash subpoenas requested by the state for defendant's medical and mental health records is granted as the state is not entitled to such records. So so the state requesting his mental and medical records, which I remember reading some documents before on that where they have no right to them because it's not the defense isn't like a insanity defense or anything where they need his records, his mental health records and medical records. So yeah, she said she denied the state for that. So that's good. Defendant's verified motion for immediate transfer of custody is denied based upon state's response and attached affidavits. So he's going to be staying in that freaking maximum security prison, which he should never have been to begin with. The defense multiple motions for Frank's hearing remain unresolved as the court is still reviewing the thousands of pages of exhibits attached to the motions, as well as the multiple hours of digital evidence submitted by counsel. The court will continue to review same defendant's motion to suppress and supplemental motions to suppress, as well as the state's responses will be set for hearing upon resolution of the defense Frank's motion. Prior to the scheduled hearing this date, Attorney Rozzi advised the court they will be withdrawing the representation of the defendant. Court accepts the representations and orders them withdrawn from the case. Counsel ordered to comply with the previously entered protective order on discovery are ordered to turn the discovery over in full to the state of Indiana to be made available to successor counsel. Court requests their cooperation with successor counsel in the best of interest of their former client, but is not requiring them to cooperate. Court will maintain the hearing currently scheduled for October 31st at 9 a.m. in the Carroll Circuit Court for successor counsel. Okay, so we're not there yet. So, okay, so now here is what this is from today, right here. Court. So yeah, today she's dated October 27th. Court notes filing by former attorney Rozzi on October 25th. So the whole notes about him trying to disqualify the judge and him trying to talk about how, you know, he was ambushed and pressured and he doesn't want to withdraw. So she's saying those notes that, you know, Rozzi filed, she's on October 25th, okay, and takes no action. So it says, okay, wait, court notes filings by former attorney Rozzi on October 25th, 2023, and takes no action. Attorney Rozzi withdrew from this matter on October 19th and is no longer counsel of record. These filings, therefore, are ordered stricken from the record. Clerk of the court ordered to remove the pleadings from the electronic case file and the chronological case summary as being filed in error. Yeah. We all saw it already, buddy. So nope. There's going to be something done about that because I'm sorry. The thing is if they go through with her as a judge, I feel like that would risk the trial, that would risk an appeal, that would risk, like, you know what I'm saying? That would risk a convict, like, let's say they do convict Richard or whatever the verdict is, that would risk him being able to appeal this stuff because, like a biased judge and how, look what she's doing. I feel like they need to just get another judge. Nobody's going to feel like he got a fair trial with her. And I feel like they could probably appeal it, right? Because there's too much now. It's too late. So anyway, so she's saying, nope. She wants that stricken. He withdrew. But he never freaking turned in anything written. He never formally withdrew. So he could argue that, I feel like, right? But she's taking it as like, nope. Anyway, so we have that. And then what do I want to do next? Yeah, we'll just do the new lawyers. So here is her new lawyers that she appointed. It's from today too. Yeah, definitely, Melissa. I feel like if he could just hang in there, like, but see, I don't know. Like, I'm not 100% convinced he is innocent, but I feel like if I was in the jury and all that they had against him was that darn freaking bullet, I would definitely not be able to say guilty if that's all the evidence. And I'm afraid that is going to be all they have. Ashley, what's up? So how do I sound though? Nobody's answered me. Like I said, I should be getting my new mic later, but hi Jamie, sorry, I thought I was saying, I thought like sometimes when I respond to somebody, I feel like it's as good as saying hi, but it probably isn't. But I did respond to something you said, and then I forget to say hi. But hey, Jamie. Okay, so here we go. Defendant remains entitled to court-appointed counsel. Court appoints attorney Robert Scremen and attorney William S. Labrato as contract public defenders to represent the defendant counsel, order to enter their appearances as public defenders on behalf of the defendant. So as filings today, we have her saying, nope, Rozzi already withdrew. He's done. His new, those documents he filed are stricken from the record. They're already stricken. They're already off the record. They're not going to be in the case files, supposedly. And then now I'm appointing these two new lawyers. Now, they're from Allen County. So, okay. So we have that. So I don't know. I was going through some groups, but I haven't had time to really like dig in. I like to go through like threads of like comments and groups because you could find out a lot of information because you have like hundreds of people that are getting information from everywhere, you know? And somebody had made a comment. I don't know if it's true, but somebody had said something like, "Oh, he's back on the case or something." But I haven't been able to find anything that says that, because all like the 2 court documents from today are saying no. She's like, he's gone. Here's the new ones. So I don't know. I think that was just somebody that was misinformed, maybe. I don't know. I haven't been able to find anything that goes with that. Okay. So media denial. So look, here is, we have all these, the news media are requesting. So we have WTHR. This is on October 20th. So they're asking for the October 31st. On behalf of all Indianapolis television stations, it is requesting the permission to have camera in the courtroom during the October 31st hearing for Richard Allen. We are willing to coordinate pool coverage of the hearing to distribute to other media attending the hearing. Our requests include video recording, audio recording, live streaming, still photography. Please consider all or some of the above in our request. I'm happy to discuss any conditions the court may have on camera in the courtroom coverage. Oh, and we'll go through the attorneys, but let me just do this real quick, the documents, and then we'll go back to that. But oh wait, that's the answer. Hold on, I want to go through all the requests first. And then we got News Nation. I'm writing you on behalf of News Nation. News Nation is looking to be part of the pool for the case of Richard Allen. If cameras are allowed inside court hearings, we would like to access to any visuals allowed. If the court needs anything else from us, please let us know. And then we have Law and Crime. Honorable Judge Francis Gall. This is the 26th. Our media organization is making an official request to have a camera in the courtroom for an upcoming pretrial hearing. Richard Allen versus State, October 31st. We respectfully request permission for either of the following: a 2-camera setup. 1 camera is operated remotely and is unobtrusive. A time in advance of the trial to set up our equipment in the courtroom. Access to the courtroom audio system. We prefer this setup because the audio is muted by the court during sidebars. We request to broadcast the hearing trial in real time. Law and Crime Network has years of experience acting as the media pool in courtrooms all over the country. We are always respectful and recognize the importance of this responsibility. Our videographer, Dan O'Neill, is local to the Carroll County area. He is trained on how to avoid showing the jury members. He is familiar with audio issues and sensitive information like sidebars. Wait, what's going on? Hey, Haunted. Okay, where are we at? We will handle properly distributing the video to other members of the media at the trial. Our organization is working with your local media and court TV. We believe our work on his last hearing was successful for the court. If there is anything you would like for us to improve, please let us know. Subject to your direction from the court regarding certain witnesses, we ask to record the hearing in its entirety. And it says, our use of media equipment in operation locations will be conformity with guidelines issued by the court. And then we have Court TV. Dear Judge Gall, on behalf of Court TV, this application is submitted for permission to televise and live stream the hearing in the above referenced case scheduled October 31st. So you have, I thought Law and Crime and Court TV were owned by the same, they were the same thing, but they're both, right. And anyway, Court TV is prepared to cooperate in a pooling arrangement with other media entities whose application to broadcast the proceedings may be granted. For this hearing, we agree to use the feed from the on-site media outlet designated to be pooled by the court. We would appreciate that any written objections to this request be served upon us, and we are notified of any hearings regarding media coverage of this matter. And then, okay, so then here is a response. You see, this is from today. The court has received requests for media coverage on October 31st at 9 a.m. hearing from the following media outlets: News Nation, Law and Crime, Court TV, Channel WTHR, or Channel 13 WTHR. In the light of the unauthorized filming and broadcasting of pre-hearing activities in the courtroom on October 19th, the court denies these requests in full. This confuses me because what are they even talking about? I thought it was pretty boring. They only had one freaking view of the freaking judge, and then they cut over a little bit as there was a, okay, so, wonder if she's talking about where the two lawyers, Rosie and Baldwin, go take Kathy in the back. Yeah, that would be pre-court hearing. Maybe they weren't supposed to be filming that, I guess. But God, I mean, what's the freaking big deal? Why? Because you were, maybe it would show like what you're freaking caught doing or something. But look, she denied it all. So that's what I was saying earlier. I'm afraid because it's based on court by hearing basis, as we read in one of those documents a little bit ago. They said that they're going to just do it based by like hearing by hearing. You know what I'm saying? Each hearing, they'll decide if they want the media. So I just feel like it's just going to be like that. Like with her, if they keep her, I don't know. I feel like she's not going to let cameras in there. Anyway, so yeah. Yeah, he got new lawyers. I just read it. Peyton. We just went over. We're gonna go over them. That's who's in the thumbnail. It's these two guys, but we're gonna go over right here. Robert Scremin, I don't know how to say his last name, and attorney William S. Librato. Now, this is the guy, William S. Librato is the guy that actually had a suspension that it's going to come out why, I guarantee. But right now, it's unknown. He was suspended for a couple weeks. So he obviously did something that he was suspended for, right? And people, the news, I mean, the reporters are trying to look into it. Has anybody heard? Has anybody been able to figure out what? No, this isn't the trial. Yeah. But I don't know. I mean, is that going to, you think she's going to end up not letting it for the trial? But then I could see that being an issue. Well, no, not really, though. There's trials that they don't let cameras, I guess. Oh, I didn't even notice that. Anyway, okay, so now let's look into the lawyers here. So here are the two. I have them in the thumbnail. That's William Librato, and then that's this Scremin guy, or however you say his name. Yes, it's exactly. I agree, Melissa. I think it is going to be because of her bias, and she doesn't want to have the media, all the eyes on her, and all the different people being able to see her. You know what I'm saying? See what she's doing. Hey, Alan, what do you think about everything? Got to admit, Judgy Gall not making the best decisions. I'm not happy with her at all. Like, just seeing her face, like, it makes me mad. You know what I'm saying? Anyway, okay, so let's look into there's a couple articles about, at least about Scremin, or Librato. Here's Scremin real quick. I haven't really been able to do like a dig because it just came out, the announcement earlier. But here's his law firm. So criminal defense, murder, narcotics, domestic violence, gun offenses, burglary, theft, probation violations, aggravated battery, resisting law enforcement, personal injury, discrimination. So this is Fort Wayne, Indiana. Criminal defense trial lawyer. 24 years of experience, former deputy prosecutor, former SWAT narcotics detective, graduate National Criminal Defense College. Let's see. We'll go over him first, then we'll go over whatchamacallit, the other guy, see if we can make out anything about what happened with him. Okay, so yeah, he's a former major felony deputy, former domestic violence attorney, narcotics detective, over 600 felony cases litigated, graduated National Criminal Defense College, member of Normal Legal Committee. So yeah, he's murder trial qualified, 24 years of experience. He's been practicing law for 24 years, has litigated over 600 major felony cases, including murder, child. I need some code words, but yeah, like CA basically. I would domestic battery and life without parole. Few lawyers have ever tried a murder case, much less obtained multiple not guilty verdicts. Mr. Scremin has tried 6 murder cases in the last year, in addition to aggravated battery, domestic violence, CA, or CM, I should say. Here, let me try to make this bigger. So there we go. Can you guys? It's hard because of the font, or because it's white. It seems like it's harder to read. For some reason. Let's do it like that. Okay. So where are we at? Gun cases. Mr. Scremin has also litigated discrimination and personal injury cases in both state and federal. Man, I wonder if they're going to say how many he got, because 6 murder cases. How many did he get? All not guilty? Let's see. He's a former deputy prosecutor with Indianapolis Drugs, Guns, and Gangs Unit, and a former deputy prosecutor with the Allen County Domestic Violence Unit. In 2017, Mr. Scremin was hired as the FCA DV Injunction for Protection Attorney for the Florida Keys and spent over a year working in Key West before relocating to Fort Wayne. He is also a graduate of the coveted National Criminal Defense College at Mercer Law School and a member of the Normal Legal Committee. Mr. Scremin began his legal career in San Francisco and later practiced in Chicago before relocating to Indiana. He is a former SWAT narcotics detective and has worked in the criminal justice field for over 35 years. Let me see if we could see. I guess I could Google like how many he's got not guilty convictions. So we have recent jury trials. So some of the jury trials that recently, so he had a serious violent felon, a murder, aggravated domestic battery, battery self-defense, the CM, murder, aggravated battery, murder, life without parole, child, murder. Okay. Verdict, Dante Curie found not guilty. So this must be one of his cases, right? I should look up all the cases and see. I will do that in a minute after we go over the other one, just to see how many he got, how many not guilties. Because if, like, let's say he got all six murder trials and 6 not guilties, that would be a good track record for Alan. But okay. So let's go to Librato. Okay, so here's an article in February 2022 about his suspension. Now, it doesn't say what. It says it's unknown. Has anybody been able to dig and find it out? Hopefully I'll be able to. I don't know, though, because I know different news channels said they haven't been able to find out yet. I'll try, but I haven't really got a chance to go back. He got a guy off at triple murder. Wow. Wait, go back up? Wait, what are you? Where are you saying that? I mean, I'll click on that, but where? Oh, here we go. Wow, Fort Wayne man found not guilty of murder and triple shooting case. Oh, this must be all his. So then this guy is sentenced to life without parole. So this one he didn't win. It looks like, right? Teen found guilty in fatal shooting over marijuana. Premiere of true crime series 2002 stabbing of Wayne High School student. I don't know. These must be all of his. Oh, this one acquits man in 2015. Huh. Well, yeah, we'll go through these in a minute. Let me go. Just give you kind of overview of the other guy, and then yeah, maybe this is what will make me happy. I'll be pretty content if they keep Rozzy on and then add these other two guys. Rozzy works with them. And because, I mean, they've already did all the freaking leg work, you know what I'm saying? And Rozzy could show him everything he's found and then get rid of freaking Judge Gall. Then I'll be pretty content. What about you guys? All right, so here is the other lawyer. Oh, I'm getting a Charlie horse. Okay, William Labrato. Fort Wayne, Indiana. The Allen Court Public Defender Board reinstated the county's chief public defender Friday. Remember, this is from 2022 article, but Friday following a 2 to 3 week suspension. The specific as to why William Labrato was given the suspension are not yet known. Labrato has been the chief public defender since January 2020, and his annual salary of $165,000 is on par with what the Allen County sheriffs earn. Board President John Serbeck, who is a retired Allen Superior Court judge, and attorney Scott Bunnell voted in favor of the reinstatement. Joe Jordan, CEO of the Boys and Girls Club, voted no. Wonder what happened. As part of his reinstatement, Labrato must abide by 3 conditions. His reinstatement is subject to his compliance, including voluntary participation in compliance with the Judges and Lawyers Assistant Program, the repayment of attorney's fees incurred during the course of the investigation, and that he refrain from any retaliation against any public defender or staff member who participated in our investigation. Bunnell read from his statement. The assistant program is an agency of the Indiana Supreme Court. Serbeck said, well respected and rigorous, Labrato will undergo a professional assessment by a clinical psychologist. Let's see what you guys said. It says, hey, what's up, US Kiwi? So you said Wolfpack Richard. Oh, you're saying to Wolfpack. Richard told law enforcement back then that he was on the bridge, what he was wearing, the car he was driving, yet it took almost 7 years to file charges, and now this show, yeah. Her familiarity with them is the problem. If she's biased, she probably picked them specifically to follow prosecution narrative. Yeah, that's the other issue, is she's the one that picked these guys. So that does make me a little bit leery. So Gloria Dallin says, I'm not sold on the Odinist conspiracy angle. I think the new team would do better with another theory of the crime. But is there another good theory though? I'm not sold on it either, Gloria Dallin, but I'm not sold. I'm not saying that it isn't true, but I'm not like 100% sold on anything, really, to be honest. But isn't that the job of the defense? Now, this isn't to you, Gloria, in general, when she's saying that, how negligence and what did she accuse them? Some of the other words that she said about their memorandum and stuff. But isn't that the whole point of a defense, is if they could try to give a narrative with another person as being the person that did it, that is ideal for a defense, right? It doesn't mean that other person had to do it and that they have to provide all this evidence that they did it, because they're not the ones on trial. But you know what I'm saying? That is what they're hired to do. So the fact that they did try to find somebody else that could be possibly involved doesn't mean that they have to think 100% that they did it and that they have to prove that the other people did it. It just needs to create some reasonable doubt that the narrative that the state is saying isn't true. You know what I'm saying? So I don't think what they did was wrong at all. I think they did their freaking job. They did a really good job, because a lot of defenses won't even be able to find another theory where involved. You know what I'm saying? Where they could find somebody else that is a possible suspect. But that is ideal, right? Isn't that what you're supposed to do? Yeah, they have to buy it. Yeah, but they don't. But the defense doesn't have to think 100%. You know what I'm saying? They just have to try to give another possibility. You know what I'm saying? They don't need to, the jury, it has to be enough. It has to create enough doubt, but it doesn't have to prove that the other people did it. It just has to create enough doubt that they didn't do it, that the person that's on trial, right? So no, it's weird. I mean, I just don't think that they did anything wrong, like the judge is trying to say. That's all. Yeah, maybe USA. It is a little tricky. I was just watching that interview with Keegan or Kagan or however you say his name. All right, so the suspension was not made public because of Indiana law. Serbeck said that they refer to personnel matters after Larry Gist, local NACP president, asked the question at the public meeting. So yeah, we might not ever know what the issue was. So I don't know though. I wonder if like like Alan could request that, like, hey, this is my public defender, I want to know what he did, like wonder if to get suspended, you know what I'm saying, because could that have an effect on how he represents him? So and then here's another article, this is from July. It says NAACP hosts community forum with the Allen County Public Defender's Office. Make this a little bit bigger. So the branch 3049 of Fort Wayne in Allen County is hosting a community forum this weekend to discuss the status of the Allen County Public Defender's Office. The forum will be held from 5 to 7 on Sunday at the temple located 4202. The event will be attended by the leaders and staff members of the Allen County Public Defender's Office. So it says that the president, Larry Gist, said the forum will give residents the opportunity to ask questions about the public defender's office, which provides legal services for defendants who cannot afford to hire a private attorney. Gist said the status of the public defender's office raised community concerns this year after an internal investigation led to the suspension of William Librado, chief public defender. The NAACP said Librado was given a suspension of 2 to 3 weeks. However, the reason for the suspension was not revealed by the Public Defender Board, which oversees the Public Defender's Office. The NAACP branch of Fort Wayne in Allen County is hosting a community forum to discuss the status of the Allen County Public Defender's Office. The forum will be 5 to 7 p.m. Sunday, July 24th. The event will be attended by, okay, hold on. So they're saying they ask questions, but I wonder if the questions are could be like to ask what's the issue? Why was he suspended? Because obviously it's not public, right? Yeah, that's just saying the same thing. Okay. And then, hold on. I just want to show you where somebody posted. Hold on 1 second. Okay, we shared that. We shared. Okay, cancel. So this is the one I was confused because it says. Now the first comment says she appointed the 2 least likely to challenge her authority attorneys possible. They appear in front of her every day in Allen County and will presumably need to continue to do so long after this case is decided. And then oh, that was about that. Never mind. I misunderstood that. Okay, this makes sense. So this person is talking about Librado. So he was reinstated as long as he refrained from retaliation. Wonder which judge he could possibly retaliate against. No, but it wasn't the judge. Wasn't it more retaliate against the other lawyers they were talking about? That article said. But anyway. Yeah, I wonder what that's all about. I'd love to know. And then, hold on, what else do I have here that I wanted to share? Oh, here's all the. So 1026, entry dated October 19th regarding order issued, entered twice in error. 1027, the transport ordered entered. This court notes filings by former attorney Razi on October 25th and takes no action. Oh, this is the one we already read. Yeah, Attorney Razi withdrew from this matter on October 19th and is no longer counsel of record. These filings, therefore, are ordered stricken from the record. Clerk of court ordered to remove the pleadings from the electronic case file in the chronological case summary as being filed in error. See, that's a little bit shady. That makes me mad too. Being filed in error? That was no error. That's bullcrap. Those are documents of what happened. Like, why would that be filed in error? Like, it's just shady, dude. What kind of freaking thing is she rolling? Like, is she what's the word for it? I don't know. What is she doing over there? I don't trust her. Do you think the trial's still gonna be in January? Hold on 1 second. I want to see something. Was that her? Yeah, Princess Gall. Okay. All right, so let's see if we could find anything else about Librato besides, and then we'll look into the cases of Scremin. But I just want to find like a general thing of Librato besides like the suspension to see what else he's all about. Give me 1 minute. Here's a Yelp review. Let me see. No, it's not giving me anything. Why can't I find anything like his information? You know, like we were reading on Scremin. Why is it? Doesn't he have a website for his stuff? Hold on, just give me. Yeah, look. I mean, I'm not able to find. I want to get some information about him. Personal injury attorney, lawyer, criminal law attorney. Columbia. Wait, hold on, what's this gonna go? Okay, I don't know why it took me there. Hold on, give me 1 minute. What is it? Librato. William S. Librato. Let me try one more time. William S. Librato. Okay. He doesn't have like a website or anything. Explore lawyers. LinkedIn. Lawyer.com. Okay, let's see. No, not lawyer.com. That's not going to work. LinkedIn. Let's see what he has for LinkedIn. Really nothing. Really nothing. Explore lawyers. So explore lawyers. Let's see. Practices in the field. And he's based out of Fort Wayne. So his law firm can be reached, but doesn't his law firm have a dang freaking website? I can't find his law firm's website for some reason. What am I doing wrong here? Oh, wait. Discover Williams law firm expertise. The firm located at Columbia Street has been subject to various user reviews, both complimentary and critical, available for exploration on our discussion forum. Here's a review for, here's one review. Wait, this is no, that's not even a review. None of these really are. Huh, anyway, let's see. What are you guys saying here? You don't think? Wait, you mean won't make it to trial because you think he's gonna not live? Is that what you mean? I wanted to do that on another YouTube. Is it that is colorful? What is that? I don't see what that is. It's the oh. You think, Alan? Wait, what? I don't understand. If you hit the downward, what does it do? What do you think it's gonna do? I'm confused about that. What? They'll give him a few extra months to prep. They had a lawyer change, yeah. All right, let me see if I could find anything else here on Librato. We already saw that. Johnson versus. Wait, is that him? Yeah, I think that is, right? Wait, he looks a lot different. Hold on a second. I think it is him, but he does. Wow, he looks a lot different, I feel like. Where's that picture? Yeah, that's him. Okay. Well, does he. Hold on a second. Let's see if there's any. I don't think. So, I don't understand why I can't find a website for his firm. Let me see if there's any, like, links. I'm hoping there'll be like some kind of link on it, and at least on this maybe where we could see. Because I would like to see how many murder trials has he worked on. You know what I'm saying? And I don't know why I can't find a website. Wouldn't like all of them these days have a website? Yeah, I guess. Hold on, Indiana. He doesn't have anything. Workplace. Wait, what is the other guy's name? Let's see if he's friends with his other lawyer buddy. See if they know each other. If they're friends on Facebook. I'm being nosy. Wait, what's the other guy's name? Robert Scrimmin. Let's just see. It might be Bob though. I don't see. Let's do Bob. No. I'm just being nosy to see if he's friends with him. Well, let's see Francis Gall. Hold on. Does Francis even have a Oh, he is! Dude, I was just joking around, but he is friends with her on Facebook. Dang. I'm not feeling good about this. You're friends with... That's not, oh, dude. That is. I know. I was just joking. I did not think. I thought he would. I was looking more that he would have been friends with the other lawyer. I was just like, oh, there's no way he's friends with the judge on Facebook. Yeah, he is. What the heck? Mm-mm. I didn't even know she had a Facebook. Dang. Oh, yeah, they're friends. Let's see what Francis is up to. See if he comments on any of her stuff. What's his name again? Why can't I remember William? Wait, let's see if Fran is friends with Scrummin, but Scrummin might not even have a Facebook. You know what I'm saying? Let's see. Robert first. Oh, she's not. She must be all private. No friends. Does that mean she doesn't have? No, she does have friends, but it won't go the other way. Dang it. Oh, I guess I could look his up and see if he has a Facebook. Robert Scremin. But hold on, let's look. Let's see what else we got going on there, Francis, because I'm not liking this. Oh yeah. Okay, hold on. Wait, what do you mean, Crystal? Nothing to see here? What does that mean? So she's not super active on here, but definitely friends with our boy Labrado. Labrado's the one that got the suspension. So he might be the more I don't know, who knows though. Hold on, let me see if there's I'm gonna go just through a couple comments, see if there's any comments by him. I doubt it, but what's his name again? Why do I keep forgetting? William Labrado. All right, so then we're gonna go the other route. We're gonna go to see if Scremin, and then who? Wait, what else did you want me to do? You said to see if Rosie and who is friends. So she has all her friends private. It won't let me even see her friends. Look, no friends to show. So I didn't know you could put your friends on private. So I can't look at her friends. So we have to go the other route. So what we'll do, hold on, we'll go to see if Robert Scremin has one, and then who's this? Hold on, let me just be a little bit nosy again, a little bit more. Hold on. Okay. Who's in your comments? Okay, we'll try Robert Scremin and or Bob Scremin and see if he even has a Facebook. We could find him. All right. All right, hold on one second. Just in case if it is. Yeah, maybe. I don't know what that. All right, hold on. Robert Scremin. How do you spell that? Hold on. I'll share my screen in 1 second. I found him. He does have a Facebook. Right here, attorney at law. Right? It's got to be him. Yep, that's him. Okay. Now let's go and see if we could, if his friends are. Dang it, he doesn't have any friends to show either. So they probably are friends, but we're not going to be able to tell because look, he has his friends private. But I'm willing to bet if she's friends with freaking William, I bet you she's friends with him too. I just have a feeling. But let's see what we got going on here. See if there's any all right, I didn't mean to do that. I meant to look at the comments. He's not very active. Dude, how crazy if she was in the comments. That would be too crazy. Or if we have, what's his name? Vibrato. But what, you wanted me to check what now? With the other lawyers? If they're friends with each other or what? Oh, I didn't mean to do that. Or should you think, hold on a second. Huh, okay. But we're going to look more into his murder cases too. But I wish I could find more on William because I want to know how many murder cases he represented. He worked on, you know. I cannot. So he was a former prosecutor from March to May. Only a year. Wait. Only like a year. Is that normal for somebody just to be a prosecutor for a year and then switch? All right, so we're not going to be able to see his friends because because he has his private or something. I didn't even know you could put your friends private because why? I mean, what would be the point of that? I don't know. I don't see the point, but all right, hold on one second. So if we do, I guess we could do to see. You're saying you want to see if Vibrato is friends with who? Like the other lawyers? What is it, Bradley? What is the other first name of the guy? Or you're saying there? Yeah, it doesn't surprise me. What's the other one, Rozzy? And what's the first name of the other guy? I'll have to go back and look. Does somebody know offhand? That is kind of interesting though that will somebody write the full names of the first names of the original lawyers? So I'm being lazy. I don't want to go look. I can, but I don't feel like it. I guess I can. You guys are gonna make me go do it. Andrew Baldwin. I don't know. I know one's Bradley, but I don't. Is it Andrew? Hold on, let me look. Oh wait, I have the. Alec Baldwin. It's not, is it? So hold on. See on this document, it's just calling him Mr. Rozzy. What? Come on, I want to know their full name. It's not putting their first names. I could just Google it. I'm probably doing the hard way by going through this document, which it looks like they're just calling them by their last name. Dang it. Okay, Bradley Rozzy, which. So what is the Baldwin? They're saying Mr. Baldwin. Come on, is it Andrew? Hold on, I'm just gonna Google it real quick because I'll see if they have a Facebook. I haven't even tried to look at their face to see if they had one. I don't know. I never. Andrew, yeah, it is Andrew Baldwin. Okay. So he could go by Drew though too, huh? Like to friends. Yeah, he's not. Wait, what? Bradley. Rozzy. All right, let me do. Yeah, I mean, I found his Facebook, but what are we trying to look about it though? I don't know what the point is. You know, to see. Are you saying you want to see if he's friends with Andrew? No, he doesn't have friends. Andrew Baldwin. No. I bet you Andrew doesn't have a Facebook. I don't know. Who's this? No. Anyway, but yeah, I think that's all. I'm gonna do my Patrick Westphal interview clips and discussion. I could do it now, but I almost want to do it as a separate one. So I guess I could end this and then put up another one doing it. Oh, and I still am going to do Adnan Saeed. Okay, I wanted to wait till I get my new mic to start that. When maybe we'll do it Saturday or Sunday. We could start it. Is it? How many of you guys have been watching the Serial podcast? I found so many other good videos to watch too after that, but that gives you a good basis to start with. How many have been watching it? Anybody? Oh, really? 15 minutes? Where? I should do that, huh? I don't know a ton about. I do. I mean, I think I know the basics. Ashley, you informed me on some stuff. I haven't been following that very close. Oh, hold on. Let me see. Where press conference? Are you sure? Have they caught him? Let's see. Press conference. Where does it say there's going to be a new one? Here's the one from 6 hours. There has also been motion to reconsider. Are you sure it's not something I read? Hold on. Motion to reconsider. Hold on. Have you? You guys in the hunts. Hold on a second. Let me see if I could find the new one. And then should I do the press? Where's the press conference at? No, don't mention another channel. Is there a news? I don't need another channel. I'm just going to find the news channel that's doing it. Hold on. I guess I could hurry up and end this and then start a new one. But now it's making me want to find the new. You said there's another document. It's making me want to see what was it about. Can you explain that a little bit better than just the title of it? Like what is it referring to? The person that talked about the document. I did read like 2 of them that were filed today, but I'm not sure if it's the one you're talking about. I don't know that wasn't the title of it. I'm trying to see if I could find any of the new ones. I don't know. I'm okay. Yeah, let me end this and then I'm trying to find the whatever document you're talking about. Whoever just said that, can you explain what it for the document? And then I'll try to find the press conference here. Hold on. let's see, press conference. As suspect search continues. There are victims of Michigan Lewiston. Expected. Okay, here we go. Expected after mystery note revealed. Okay. Well, let me end this, and I guess we could. Press conference must be everywhere. Big mess. All right, I'm going to end this, and then, like I said, I'm going to just put up that. We could do the press conference. I'll put it right up. And then, like I said, I have that Patrick Westfall. Look out for that video coming up. And then this weekend, either Saturday or Sunday, we could do maybe a late afternoon. We could start with the Adnan. So you guys watch Serial Podcast. That's what we'll start off talking about. And then we'll talk about that case. All right, let me end this. I'm just trying to find a news channel that is gonna do that in 15 minutes. All right, bye guys. Just come back for the press conference. We gotta break 100 people. We didn't even break 100 people in here, guys. Help me. Gotta make the views so I could pay for my my new whatchamacallit microphone that I shouldn't have got. All right. Well, don't wait. I did a clip where I picked out some important stuff. All right, bye guys. Come back, okay? I'm gonna find the press conference. Oh wait, I have to end it over here. Yeah.